ever feel like you're signing your life away whenever you agree to like a contract?
Oh, yeah.
I mean, who actually reads all those tiny print clauses?
Right.
What if those clauses were basically saying, we're not responsible if things go wrong? That's what we're diving into today. The fascinating world of exemption clauses in UK contract law.
Okay.
We've got excerpts from a legal document kind of breaking it all down, and let me tell you, these clauses can be trickier than they look.
Yeah, they can be a real double-edged sword,
Yeah.
On the one hand, they protect businesses from, potentially huge losses.
Right.
But on the other hand, they can really leave individuals in a tough spot if something goes wrong.
Okay. So let's cut to the chase.
Sure.
What exactly is Snodgrass an exemption clause? Like, is it like a legal loophole
Right.
that lets companies just get away with anything?
Well, I think it's more about allocating risk.
Okay.
Think of it as a way to, predetermine who takes the hit if things go sideways in a business deal.
Okay.
And sometimes they're essential for making those deals happen in the first place.
Right.
Yeah.
Our source actually gives this great example of a small-time ship owner
Okay.
with just one vessel, right?
Right.
And a huge company wants to ship, like, risky cargo. But the little guy, he can't afford to replace the whole ship if something goes wrong. An exemption clause could actually make the deal possible
Right.
by shifting the risk to the company.
Exactly. It allows both parties to kind of engage in a transaction that might otherwise be too risky for one of them to take on.
Okay, that makes sense. But doesn't that kind of go against the whole point of contracts? I mean, if you promise something, shouldn't you be held to it?
Well, you've hit on a key tension in contract law.
Okay.
That's the balance between freedom of contract and fairness.
Okay.
Courts generally allow these exemption clauses because they help the wheels of commerce turn smoothly.
Right.
But they also step in when those clauses become too one-sided.
Right.
Or unfair.
So there are rules, right?
There are.
It's not just a free-for-all.
Definitely not.
Our source lays out a 3-point checklist for when an exemption clause is actually enforceable.
Okay.
I think this is where it gets really interesting for our listeners.
Absolutely.
So head us with it.
These are the key requirements. Incorporation, construction, and statutory provisions.
Okay.
Each one is crucial for understanding if that exemption clause actually holds water.
Okay, let's break this down.
Sure.
Starting with incorporation.
Right.
Basically, the source says the clause has to be a legit part of the contract. Just sneaking it in somewhere random won't do.
Right. It needs to be clear that both parties agreed to it. Think of it like a building block of the agreement. It has to be integrated properly for the structure to hold up.
Okay, so there are a few ways to make sure a clause is incorporated correctly.
Exactly.
Like if you sign a contract, you're basically saying you agree to all the terms, including any exemption clauses, right?
Exactly. Your signature acts as a clear sign of consent. But even without a signature, a clause can still be incorporated.
Okay.
Through proper notice.
Okay.
This means it has to be included in a document where you normally find contract terms.
Ugh.
And you have to be made aware of those terms before or at the time you enter the contract.
So like those terms and conditions links that we all click on without reading?
Yes.
Those can actually include exemption clauses.
Absolutely.
Yeah.
They absolutely can. It's amazing how many people just click agree without even glancing at what they're agreeing to.
Right, right. I feel like I've blindly agreed to a lot of things.
Well, those terms are legally binding, and exemption clauses within them can have real consequences.
Okay, point taken. I'll be reading those more carefully from now on. The third way our source mentions is previous course of dealings. So if two parties have done business a certain way for a long time, their usual terms, including any exemption clauses, can be considered part of the deal.
Right.
Even if they don't spell them out every single time.
Think of it like an unspoken agreement based on their established history. But it has to be a consistent pattern, not just a one-off situation.
Okay, so we've tackled incorporation.
Right.
Next up is construction.
Okay.
This one seems particularly tricky because it's about how courts actually interpret these clauses.
And courts hate ambiguity.
Okay.
They're looking for clear, specific language.
Right.
A vague clause that tries to exclude responsibility for everything under the sun simply won't fly.
Okay, speaking of vague language, the source mentions this legal principle called contra proferentum.
Ah, yes.
It sounds very Latin and intimidating.
It does, doesn't it?
What's that all about?
It's actually a very powerful tool for consumers.
Okay.
It means that if the wording of an exemption clause is unclear, the court will interpret it against the person trying to use it to escape responsibility.
Oh.
So the company that drafted the contract, they better make sure their wording is precise.
Otherwise, it could backfire big time. There's a case in our source that really brings this home. It involves a car that was overloaded
Okay.
and an insurance policy that didn't clearly define load.
Ah, yes, a classic example.
Right.
The insurance company tried to wriggle out of paying a claim because the car was carrying more people than it was designed for.
Oh, wow.
But the court sided with the car owner because the term load was too vague.
Okay.
Did it refer to weight, number of passengers, or something else entirely? The court found that the ambiguity had to be resolved in favor of the insured party.
Oh, so lesson learned, precise language matters.
Yeah.
Okay, I have to ask, what about negligence?
Mm-hmm.
Can a company really write a clause that says they're not responsible if they do something careless
Right.
that harms someone?
That's a very complex area.
Right?
UK courts are wary of letting anyone completely dodge consequences for negligence.
Sure.
It's a matter of public policy.
Yeah.
We want people to be held accountable for their actions.
Of course, of course. So how do courts decide if an exemption clause actually excludes negligence?
Right.
Is there a specific test?
There is. It's called the Canada Steamship Lines test.
Okay.
And it's all about scrutinizing the wording of the clause.
Right.
Judges look for clear and unambiguous language that specifically mentions negligence
Okay.
or uses words that are undeniably synonymous with it.
But what if the clause doesn't explicitly mention negligence?
Right.
Is it automatically thrown out?
Not necessarily.
Right.
The court will examine whether the wording, despite not using the word negligence, is broad enough to encompass situations where negligence is the only plausible explanation for the harm that occurred.
Oh, okay. So it's a higher bar to clear,
It is.
but not impossible. It sounds like courts are really trying to balance the need for clear contracts with the importance of holding people accountable for careless actions.
Exactly. It's a delicate balancing act, and each case is judged on its own merits.
Okay, so far we've established that these clauses can be tricky, and they're definitely not a free pass for businesses to act recklessly.
Right.
But even when a clause seems airtight, our source says there are situations where it just won't fly.
Okay.
What if there's like a major breach of contract?
Yeah,
That has to be a deal breaker.
that can be, yeah. Think of it this way. You order a pizza, and they deliver a salad. That's not just a minor deviation.
Right.
It's a fundamental breach of the agreement. The company can't just hide behind an exemption clause and say, oh, we're not responsible if you didn't get what you expected.
Right. It's a total bait and switch.
Exactly.
So even with these clauses, there are limits to what companies can get away with.
Absolutely. And if a company misrepresents what an exemption clause actually covers, like downplaying its scope to make it seem less restrictive, that can also render the clause unenforceable.
Right.
Courts are on the lookout for those bad faith tactics.
So no sneaky tricks allowed. It seems like the law is really trying to create a fair playing field, even in this complex world of contracts.
It is.
But now I'm really curious about like the big guns of UK legislation.
You're talking about the Unfair Contract Terms Act 1977, more commonly known as UCTA.
Exactly. Our source material emphasizes that UCTA is absolutely key for understanding how exemption clauses work in business deals. It's all about making sure things don't get ridiculously unfair, especially for the little guy going up against a massive corporation.
You got it, yeah.
Yeah.
UCTA's core purpose is to regulate exemption clauses in contracts relating to what's called business liability, which covers things done in the course of a business.
Okay.
But it's important to note that business has a wide definition here.
So it's not just about traditional companies buying and selling goods.
No, it also covers professions, government bodies, even local authorities. So a contract between a lawyer and their client, for example, would fall under UCTA.
Interesting. So a wide range of activities are covered. But what about individuals? Does UCTA apply to them? I remember seeing something in the source about dealing as a consumer.
You're right. UCTA offers greater protection to individuals acting as consumers.
Okay.
If a contract is made outside the course of a business, it's considered a consumer contract.
Right.
And certain provisions of UCTA won't apply.
So a contract for a personal loan would likely be considered a consumer contract,
Brogmalpol.
while a contract for supplies for your business wouldn't be.
Exactly. The context of the transaction matters a lot. There's actually a fascinating case that illustrates this distinction.
Okay.
In R&B, Custom Brokers, Co. Ltd v. United Dominions Trust Ltd.
Oh.
A shipping company bought a car for their director to use.
Mm-hmm.
When the car had problems, they sued for breach of contract.
Right.
The big question was, were they acting as a business or a consumer when they bought the car?
So even though it was a company making the purchase, they might not have been considered a business in that specific instance.
That's right.
Wow.
The court ultimately decided that since buying a car wasn't a core part of their shipping business, they were acting as consumers in that particular transaction.
Wow. So even seasoned business folks can sometimes benefit from consumer protections. It really comes down to the specifics of the deal.
It does, yeah.
But I'm curious, are all business contracts covered by UCTA, or are there exceptions?
There are some key exceptions. Contracts related to insurance, intellectual property, land, company shares, things of that nature, they're exempt from some of the most important parts of UCTA.
Okay.
International shipping contracts and charter parties also fall outside its scope.
So if I'm signing a lease for an apartment or dealing with an employment contract, UCTA might not apply.
That's right. Those areas are governed by their own sets of rules and regulations.
Okay, good to know. But for those contracts that DO fall under UCTA, what are the essential things to watch out for?
It's crucial to remember that UCTA doesn't just apply to, classic exemption clauses that try to completely eliminate liability.
Mhm.
It also covers clauses that attach conditions to liability, limit available remedies, or even restrict what evidence can be used in court.
Wow, so UCTA has a pretty broad reach. It's not just about outright exclusions of responsibility.
Exactly. It's designed to prevent businesses from using any sneaky tactics to avoid being held accountable.
Okay, so UCTA is like the watchdog, making sure businesses don't overstep with these exemption clauses.
You got it.
But how exactly does it work in practice?
Mm.
The source mentions something about clauses that limit people's rights or remedies.
Right. Let's pick up there next time.
This has been an incredibly insightful deep dive so far. We've covered a lot of ground, but there's still more to explore. In the next part of our deep dive, we'll delve even deeper into the specifics of UCTA and the Consumer Rights Act. We'll examine their provisions in more detail and explore how they interact with each other. We'll also look at some additional case examples that illustrate how these acts are applied in practice. Stay tuned.
Welcome back. Last time we really got into the weeds with exemption clauses, those sneaky little bits of contract language
Right.
that try to shift risk around. We talked about the 3 key requirements for them to be enforceable: incorporation, construction, and statutory provisions.
And we can't forget the big guns,
Yes.
the Unfair Contract Terms Act, or UCTA, which puts the brakes on businesses trying to use these clauses to, completely avoid responsibility.
Right. It's like a referee in the contract game.
Making sure no one's pulling any fast ones. You mentioned that one of UCTA's key roles is preventing businesses from using exemption clauses to completely strip away someone's rights or remedies if things go wrong. I'm ready to dig into that.
Absolutely. One of the most important provisions is Section 2, which deals specifically with attempts to exclude or restrict liability for negligence. Remember, negligence essentially means acting carelessly and causing harm.
Right, and we talked earlier about how courts don't like it when businesses try to use these clauses to dodge consequences for their own negligence. So what does Section 2 actually say?
It's very clear. You absolutely cannot exclude or restrict liability for death or personal injury resulting from negligence. No ifs, ands, or buts.
So no matter what the contract says, if a business causes someone harm through their own carelessness, they can't just waive an exemption clause and walk away.
Precisely. This provision is all about protecting people's, fundamental right to safety and well-being.
Yeah.
It recognizes that some harms are simply too serious to allow businesses to contract out of responsibility.
That makes a lot of sense. What about damage to property?
Mm-hmm.
Does UCTA address that as well?
It does, yes. Section 2 also covers liability for damage to property caused by negligence.
Yeah.
But there's a slight nuance here.
Okay.
In these cases, a business can exclude or restrict their liability, but only if the exemption clause passes the test of reasonableness.
So it's not like an outright ban,
Right.
like with personal injury. But how do you determine reasonableness in this context? It seems pretty subjective.
You'd think so, but UK law actually provides a framework for this. Section 11 of UCTA outlines a number of factors that courts consider when deciding whether an exemption clause is reasonable.
Okay, so there's a method to the madness.
There is.
What are some of the key factors they look at?
One of the most important is the relative bargaining power of the parties.
Okay.
If the party benefiting from the exemption clause is in a much stronger position, say a huge corporation versus an individual consumer, the court will be much less likely to consider that clause reasonable.
So they're looking out for David versus Goliath situations.
Exactly. They want to make sure contracts aren't being used to exploit those in weaker bargaining positions. Another key factor is whether the customer was aware of the exemption clause.
Okay.
If it was buried in the fine print and never brought to their attention, that goes against the business trying to enforce it.
So transparency is key. No hiding crucial information in a sea of legalese.
Right. And the court will also consider whether the goods or services involved were specially made for the customer. If so, the exemption clause might be considered more reasonable, as there's a greater degree of customization and understanding between the parties.
Okay, so if I commission a bespoke piece of furniture, for example,
Right.
the maker might have more leeway to include an exemption clause.
Potentially, yes. The court would weigh the specific circumstances and the balance of power between you and the furniture maker. They'll also look at whether you had other options available. Could you have bought a similar piece of furniture from someone else without that exemption clause?
So competition comes into play.
It does.
If there are plenty of alternatives, the court might be less sympathetic to a business trying to shield themselves with like an overly broad exemption clause.
Exactly. And finally, they'll consider whether the contract was a standard form contract, the kind that's used over and over with little or no room for negotiation.
Like those online terms and conditions we all just click agree to without reading?
Precisely, yeah. Because those contracts are often heavily skewed in favor of the business, courts are much more likely to scrutinize exemption clauses within them. They want to make sure consumers aren't being unfairly disadvantaged.
Okay, so it's not just about whether a clause like technically exists, it's about whether its inclusion is fair given all the surrounding circumstances.
Right.
UCTA really does seem like a powerful tool for keeping things balanced. But I'm curious about how all of this works in practice. Does UCTA actually have teeth?
It does.
Can you give us some examples of cases where it's been used to like strike down unfair exemption clauses?
Absolutely, yeah. There are tons of cases where the courts have relied on UCTA to protect parties from unreasonable exemption clauses. One classic example is George Mitchell, Chester Hall, LTD v. Finilock Seeds Ltd.
Okay.
It involves a farmer who purchased cabbage seeds from a supplier.
Okay.
The contract included an exemption clause limiting the supplier's liability to just the cost of the seeds, even if the seeds turned out to be defective.
So if the seeds were duds and the farmer lost his entire crop, the supplier would just shrug and say, here's your refund for the seeds.
Basically.
That seems ridiculously unfair.
It does, and the House of Lords, the highest court in the UK at the time, agreed. They found the exemption clause to be unreasonable, especially considering the power imbalance between the small farmer and the large seed supplier. They recognized that the potential losses for the farmer were far greater than just the cost of the seeds.
So UCTA came to the rescue and prevented like a huge injustice.
It did.
I can see why it's such a crucial piece of legislation. Do you have any other examples that illustrate how UCTA works in the real world?
Another great case is Granville Oil and Chemicals, Ltd v. Davies Turner & Co. Ltd.
Okay.
It involved a company that shipped drums of chemicals, and the shipping company included an exemption clause in their standard terms and conditions. This clause limited their liability to a fixed amount per package, even if the loss was caused by their own negligence.
So if they damaged a whole shipment of valuable chemicals, they'd only be liable for a small amount per drum.
That's right.
That seems pretty risky for the company shipping the chemicals.
It was. And the court acknowledged that this type of clause could be problematic. But they also recognize that standard terms and conditions are often necessary in the business world and that companies need ways to manage their risk.
So it's a balancing act
Yeah.
between protecting customers and allowing businesses to operate efficiently.
Exactly. In this particular case, the court found the exemption clause to be reasonable. It was clearly worded, the customer was aware of it, and they had the option of getting insurance to cover any potential losses.
Okay, so the court really looked at the context of the situation
They did.
and the overall fairness of the arrangement.
Precisely, yeah. And this case shows that even though exemption clauses aren't inherently evil, they have to be used responsibly and transparently.
This is all so fascinating. I'm starting to see how these seemingly boring clauses can actually lead to some pretty dramatic legal battles.
They certainly can, yeah. And the outcomes of these cases often hinge on the interpretation of UCTA.
Okay, so we've really unpacked the ins and outs of UCTA, but I remember you mentioned another important piece of legislation, the Consumer Rights Act, 2015. How does that fit into all of this?
The Consumer Rights Act is like UCTA's partner in crime, but it specifically focuses on protecting individuals in consumer contracts. It introduces this concept of fairness as a key test for determining whether a term in a consumer contract is valid.
Okay, so it's all about making sure businesses aren't taking advantage of consumers.
Right.
But how do you actually define fairness?
Right.
It seems like a pretty subjective concept.
You're right, it can be a bit tricky.
Okay.
But the Consumer Rights Act provides some helpful guidance by outlining a gray list of terms that are likely to be considered unfair.
Okay.
This list includes things like clauses that exclude or limit liability for death or personal injury caused by the trader's negligence, or clauses that allow the trader to unilaterally change the terms of the contract without a valid reason.
So if a company tries to slip in any of those terms, big red flags should go up.
Absolutely, yeah. The Consumer Rights Act gives consumers much more power to challenge these sorts of sneaky terms and ensure that they're treated fairly.
Okay, so the Consumer Rights Act is a powerful tool for protecting consumers. But before we wrap up this part of our deep dive, can you give us a quick recap of what we've covered?
Certainly, yeah. The key takeaways are that exemption clauses are contract terms that try to limit or exclude liability. UCTA regulates these clauses in business-to-business contracts, ensuring they don't become too one-sided. UCTA places strict limits on excluding liability for negligence, especially when it comes to death or personal injury. For other types of losses, UCTA uses a reasonableness test to determine if an exemption clause is enforceable. Several factors contribute to this reasonableness assessment, including bargaining power, transparency, and the availability of alternative options. And the Consumer Rights Act specifically protects individuals in consumer contracts by introducing a general fairness test and highlighting potentially unfair terms.
Wow, that's a lot of ground covered. It's incredible how much complexity is packed into these seemingly simple clauses.
It's a testament to how important contracts are in our society and how much effort goes into ensuring that they're used fairly and responsibly.
This has been an incredibly informative deep dive so far. We've gone from feeling intimidated by these tiny print clauses to feeling like we actually have the tools to understand them and even challenge them if needed.
It is amazing how a little knowledge can shift the balance of power.
It really is.
Yeah.
So, dear listener, the next time you see one of those exemption clauses, remember what we've talked about today. Don't just skim over it. Take a moment to understand what it means. You might be surprised by the impact it could have.
And remember the resources at your disposal. With a bit of vigilance and the right information, you can navigate the world of contracts with confidence.
That's it for our deep dive into the world of exemption clauses. Thanks for joining us on this journey. We hope you've learned something new and feel more empowered to protect your interests. Until next time, happy contracting.
Okay, so we're back for like the final part of our exemption clause exploration.
Right.
We've gone deep into the legal theory, the acts of parliament, even some like landmark cases.
But let's get down to like brass tacks. What can our listeners actually do to protect themselves when faced with these clauses in real life?
It's all well and good knowing the law,
Right.
but putting it into action is where the rubber meets the road, as they say.
Exactly. So let's translate all this legal jargon into like practical advice.
Right.
Where do we even begin?
Well, the first and most important step might seem obvious,
Okay.
but you'd be surprised how many people skip it. Read the fine print.
Right.
I know, it's boring, it's tedious, it's like reading a dictionary written in a foreign language, but it's crucial.
Because those tiny print clauses, the ones we all tend to gloss over, they can have a massive impact.
They can.
They can determine who's left holding the bag if something goes wrong.
Precisely, yeah. So take the time to understand what you're agreeing to. If something seems unclear or ambiguous, don't hesitate to ask for clarification. Whether you're dealing with a company or another individual, it's always better to be safe than sorry.
And remember, you have the right to negotiate. Just because a contract is presented to you in a certain way doesn't mean you have to accept it as is. If there's an exemption clause that you're just uncomfortable with, try pushing back. You might be surprised at how willing the other party is to compromise.
Absolutely, yeah. Don't be afraid to stand up for your rights. And if you're feeling overwhelmed or unsure about something, remember, there are resources out there to help you. Organizations like Citizens Advice and the Trading Standards Institute, they provide guidance and support for consumers facing contract disputes.
Those are great resources, and there's a wealth of information online as well.
Oh, absolutely.
Websites like Which and Money Saving Expert, they offer comprehensive guides and advice on consumer rights, including specific information on exemption clauses.
Exactly. And don't underestimate the power of a good internet search. A quick search for exemption clauses explained or unfair contract terms can yield a treasure trove of helpful articles and advice.
Right. Knowledge is power, especially when it comes to navigating the complex world of contracts. And if you're dealing with like a particularly complex situation, like a business dispute with high stakes, don't be afraid to seek professional legal advice.
Definitely, yeah. A solicitor specializing in contract law can help you understand your rights, assess your options, and protect your interests. It's an investment worth considering, especially when the potential consequences are significant.
Okay, so we've covered reading the fine print, asking for clarification, negotiating terms, seeking help when needed. Any other practical tips our listeners should keep in mind?
Here's one that's often overlooked. Document everything.
Oh, okay.
Keep copies of all contracts, correspondence, any other relevant documents. This can be invaluable if a dispute arises down the line.
Right. It's so much easier to make your case if you have a clear paper trail to, like, back it up.
Exactly, yeah. And be proactive. If you anticipate potential issues, try to address them up front. For example, if you're hiring a contractor, make sure the contract clearly defines their responsibilities, the scope of work, and any potential liabilities.
So think ahead and try to avoid problems before they even arise.
Exactly, yeah. A little foresight can go a long way in preventing headaches down the road.
Wow, this has been an incredibly empowering deep dive. We've gone from feeling intimidated by those tiny print clauses to feeling like we actually have the tools to understand them and even challenge them if needed.
It's amazing how a little knowledge can shift the balance of power.
It really is. So, dear listener, the next time you see one of those exemption clauses, remember what we've talked about today. Don't just skim over it. Take a moment to understand what it means. You might be surprised by the impact it could have.
And remember the resources at your disposal. With a bit of vigilance and the right information, you can navigate the world of contracts with confidence.
That's it for our deep dive into the world of exemption clauses. Thanks for joining us on this journey. We hope you've learned something new and feel more empowered to protect your interests. Until next time, happy contracting.